round 2. The DG only approved the submission recommending the appointment of C squared in round 2. And we submit that he acted arbitrarily and without any authority. We submit that there was no reason or process to extend the C squared contract. They don't offer any reason for this entirely summary contractual extension other than speculating that the department considered it cost effective to ask C squared deliver Echo Green and Mr. Log's commodities without any form of procurement process. And we say that this doesn't justify the wholly deficient manner in which the contract was extended. There was no RFQ, no comparison of quotes, nothing. Indeed, it appears that the only reason to extend the C squared contract was the department's irrational choice to enter contracts with companies unable to deliver commodities nationally. And we submit that this is an illegitimate reason to extend the C squared contract and can't justify the departure from the procurement process. We then discuss irrationality.
Okay, you earlier argued that regulation 16.4a, I think it is, applies, right? So, which means your case is that there was an emergency. If you want to rely on that regulation, it means your case is that this was an emergency procurement.
There's no doubt,
which means
that we were.
Yes, which means the formal procurement process could be departed from. However, there were requirements regarding that deviation, but I don't see where you make out the case that a deviation, those requirements regarding the approval of a deviation was not granted. And in any event, even if a deviation is approved, the procurement needs to be fair, it needs to be equitable, it must be cost-effective, competitive, and that's where it looks like the factual allegations you make may support a finding that those values were not complied with.
Absolutely,
in terms of the process that was.
I think we all accept, and your ladyship has accepted this in several other matters, that we were in an emergency situation. Yes. But that 16A4 still required you.
Yeah, it doesn't mean that there are no procurement requirements in an emergency. There still are.
It still had to be fair, it had to be competitive, and there had to be some kind of bidding process to ensure that prices remain within a band of.
And there are requirements regarding when can a one supplier be resorted to.
Yes, my lady.
But you don't make up that case, Mr. Arendse.
We submit that we do, my lady. We submit that we do. For example, under the heading of bad faith and ulterior purpose, we mentioned 3 facts: undeniable, irrefutable facts that it was bad faith and fraud that materially influenced the DG's decision. Firstly, we point out that the CEO of Santaco benefited from these appointments. They provided a list of companies to the DG, who in turn appointed the suppliers in flagrant breach of the procurement laws, only to end up benefiting Santaco's CEO. The implication is that either the CEO defrauded the department or the DG was party to a fraud. In either case, the decision should be set aside given the role deception played in these appointments. Echo Green failed to disclose their relationship to Mr. Buthelezi, They completed a declaration interest form. These forms require all bidders to disclose any relationship, family, friend, other with a person employed by the state and who may be involved in the evaluation of the bid.
So you rely on these allegations for in finding that the procurement process was not fair?
Yes, my lady. Yes. There's a number of grounds, and the way
they set out, you know, as you can see, I'm gonna have to struggle and work out, okay, which allegations actually do support whatever finding, because you've clustered them under the malafide ground, right? But they apply elsewhere as well.
They overlap, my lady. They overlap. Yeah. I mean, for example,
so I'm saying to you, in terms of the procurement process, Mr. Arendse, the grounds you expressly rely on, right, is largely what we've debated.
Yeah.
Right. So regarding whether the process was unfair, or rather whether it was fair, whether it was equitable, whether it was competitive, it seems the facts you rely on are the facts you rely on for a finding that there was malafide.
Yes, ma'am.
Right. And hence I'm saying to you, I'm going to have, you know, in applying the law, you know, it appears that I'll have to assess these facts to see what finding in terms of non-compliance with the applicable procurement process, what finding do they support?
And we submit, my lady, that this is with respect a clear-cut case where there simply was no compliance with the procurement requirements, either as laid down by Treasury or in the alternative, even if one disregards the Treasury regulations and instruction number 8, then the broad heading under 217 of our Constitution, which requires a fair, competitive bidding process. It just didn't happen.